The right to counsel established in Miranda was one of a series of recommended procedural safeguards that were not themselves rights protected by the Constitution, but were instead measures to ensure that the right against compulsory self-incrimination was protected. I don't think that there's any need to go to lawyer dog. I think you can just focus on, why don't you just give me a lawyer? Hello everyone, I'm Leonard French, your favorite copyright attorney, and today I've got a story out of the Supreme Court of Louisiana. A suspect was being interviewed for sexual misconduct with a minor allegations, and he referred to a lawyer by saying, "Just give me a lawyer, dog." And the Supreme Court of Louisiana did not think that that was a unambiguous statement requesting a lawyer. So let's go over how that may have happened. So this is the opinion, or rather should I say a concurring opinion, out of the Supreme Court of Louisiana. This is State of Louisiana versus Warren de Mesme, or I'd like to think that the S is silent and we call him Warren de Meme. What do you think? On writ of certiorari to the Court of Appeal, so we're on an appeal. A writ of certiorari is the petition that asks for the appeal. And this is Judge Christen writing a concurrence. So the judges made the decision in some other document, and then this concurrence is sort of explaining the reasoning behind it. Judge Christen writes, "I agree with the court's decision to deny the defendant's writ application, their petition for appeal, to deny the petition for appeal, and write separately to spotlight the very important constitutional issue regarding the invocation of counsel during a law enforcement interview, the request for counsel for attorneys, for a representative. The defendant voluntarily agreed to be interviewed twice regarding his alleged sexual misconduct with minors. At both interviews, detectives advised the defendant of his Miranda rights. We're going to go over that in a moment. And the defendant stated he understood those rights and waived those rights. And that's the right to have an attorney present, basically. Nevertheless, defendant argues that he did invoke his right to counsel, and the basis for this comes from the second interview, where the Judge Christen, believes the defendant ambiguously referred to a lawyer, prefacing a statement with, "If y'all, this is how I feel, if y'all think I did it, I know that I didn't do it, so why don't you just give me a lawyer, dog, 'cause this is not what's up." As this court has written, if a suspect makes a reference to an attorney that is ambiguous or equivocal, in that a reasonable police officer, in the light of the circumstances, would have understood only that the suspect might be invoking his right to counsel, the cessation of questioning is not required. So the judge is saying that if the suspect might be invoking his right to counsel, the police do not have to stop questioning and go get him an attorney. He refers to a U.S. Supreme Court case, Davis versus United States, and we're going to go over that. And then he says, in my view, the defendant's ambiguous and equivocal reference to a lawyer dog does not constitute an invocation of counsel that warrants termination of the interview and does not violate Edwards v. Arizona. So if you're thinking to yourself, what in the world, how could a person misinterpret "just give me a lawyer, dog" as someone asking for a literal lawyer space dog, you're with me on this one. But let's continue and see what the judge was referencing in Davis versus United States, a U.S. Supreme Court case from 1994. This is a unanimous opinion delivered by Justice O'Connor, in which Justice Rehnquist, Scalia, Kennedy, Thomas joined. Scalia wrote his own concurring opinion, and Justice Souter filed another concurring opinion in which Blackmun, Stevens, and Ginsburg all joined. So this is a unanimous opinion. So Justice O'Connor writes, in Edwards v. Arizona, 1981 U.S. Supreme Court case, We held that law enforcement officers must immediately cease questioning a suspect who has clearly asserted his right to have counsel present during custodial interrogation. In this case, Davis, we decide how law enforcement officers should respond when a suspect makes a reference to counsel that is insufficiently clear to invoke the Edwards prohibition on further questioning. Poole brought trouble not to River City, but to the Charleston Naval Base. Petitioner, a member of the U.S. Navy, spent the evening of October 2nd, 1988, shooting Poole at a club on the base. Another sailor, Keith Shackelford, lost a game and a $30 wager to Petitioner, but Shackelford refused to pay. After the club closed, Shackelford was beaten to death with a pool cue on a loading dock behind the commissary. The body was found early the next morning. The investigation by the Naval Investigation Service gradually focused on Petitioner. Investigative agents determined that Petitioner was at the club that evening, that he was absent without any authorization from his duty station the next morning. The agents also learned that only privately owned pool cues could be removed from the club premises, and that Petitioner owned two, one of which had a bloodstain on it. The agents were told by various people that Petitioner had either admitted committing the crime or had recounted details that clearly indicated his involvement in the killing. On November 4th, 88, Petitioner was interviewed at the NIS office. As required by military law, the agents advised Petitioner that he was a suspect, that he was not required to make a statement, that any statement could be used against him at trial by court-martial, and that he was entitled to speak to an attorney and to have an attorney present during questioning. Petitioner waived his rights to remain silent and to counsel both orally and in writing. About an hour and a half into the interview, Petitioner said, "Maybe I should talk to a lawyer." According to the uncontradicted testimony of one of the interviewing agents, the interview then proceeds as follows, quote, "We made it very clear that we're not here to violate his rights, that if he wants a lawyer, that we will stop any kind of questioning with him, that we weren't going to pursue the matter unless we have it clarified. Is he asking for a lawyer, or is he just making a comment about a lawyer?" And he said, "No, I'm not asking for a lawyer." And then he continued on and said, "No, I don't want a lawyer." Okay, remember that part. After a short break, the agents reminded Petitioner of his rights to remain silent and to counsel. The interview then continued for another hour until Petitioner said, "I think I want a lawyer before I say anything else." At that point, questioning ceased. At his general court-martial, Petitioner moved to suppress statements made during the interview. The military judge denied the motion, holding that the mention of a lawyer by Petitioner during the course of the interrogation was not in the form of a request for counsel, and that agents had properly determined that Petitioner was not indicating a desire for or invoking his right to counsel. Petitioner was convicted on one specification of unpremeditated murder in violation of the U.S. military code. He was sentenced to confinement for life, to dishonorable discharge, forfeiture of all pay and allowances, and a reduction in rank to the lowest pay grade. The convening authority approved the findings and sentence. The Navy Marine Corps Court of Military Review affirmed. The United States Court of Military Appeals granted discretionary review and also affirmed. The court recognized that the state and federal courts have developed three different approaches to a suspect's ambiguous or equivocal request for counsel. Some jurisdictions have held that any mention of counsel, however ambiguous, is sufficient to require that all questioning cease. Others have attempted to define a threshold standard of clarity for invoking the right to counsel, and have held that comments falling short of the threshold do not invoke the right to counsel. Some jurisdictions have held that all interrogation about the offense must immediately cease whenever a suspect mentions counsel, but they allow interrogators to ask narrow questions designed to clarify the earlier statement about the suspect's desires requesting counsel. Applying the third approach, the court held that Petitioner's comment was ambiguous, that the NIS agents properly clarified Petitioner's wishes with respect to counsel before continuing questioning him about the offense. Although we have twice previously noted the varying approaches the lower courts have adopted with respect to ambiguous or equivocal references to counsel during custodial interrogation, we have not addressed the issue on the merits, so we granted certiorari here to do so. Again in Davis. The Sixth Amendment right to counsel attaches only at the initiation of adversary criminal proceedings. And before proceedings are initiated, a suspect in a criminal interrogation has no constitutional right to the assistance of counsel. Nevertheless, we held in Miranda v. Arizona, a 1966 Supreme Court case, that a suspect subject to custodial interrogation, which means interrogation or interview in custody, has the right to consult with an attorney and to have counsel present during questioning, and that police must explain this right to him before questioning begins. The right to counsel established in Miranda was one of a series of recommended procedural safeguards that were not themselves rights protected by the Constitution, but were instead measures to ensure that the right against compulsory self-incrimination was protected. U.S. Constitution Amendment 5, no person shall be compelled in any criminal case to be a witness against himself. The right to counsel recognized in Miranda is sufficiently important to suspects in criminal investigations, we have held, that it requires the special protection of the knowing and intelligent waiver standard. If the suspect effectively waives his right to counsel after receiving the Miranda warnings, law enforcement officials are free to question him. But if a suspect requests counsel at any time during the interview, he is not subject to further questioning until a lawyer has been made available or the suspect himself reinitiates conversation. This second layer of prophylaxis for the Miranda right to counsel is designed to prevent police from badgering a defendant into wavering his previously asserted Miranda rights. To that end, we have held that a suspect who has invoked the right to counsel cannot be questioned regarding any offense unless an attorney is actually present. It remains clear, however, that this prohibition from further questioning, like other aspects of Miranda, is not itself required by the Fifth Amendment's prohibition on coerced confessions, but is instead justified only by reference to its prophylactic purpose. The applicability of the rigid prophylactic rule of Edwards requires courts to determine whether the accused actually invoked his right to counsel. To avoid difficulties of proof, and to provide guidance to officers conducting interrogations, this is an objective inquiry. Invocation of the Miranda right to counsel requires, at a minimum, some statement that can reasonably be construed to be an expression of a desire for the assistance of an attorney. But if a suspect makes a reference to an attorney that is ambiguous or equivocal, in that a reasonable officer in light of the circumstances would have understood only that the suspect might be invoking the right to counsel, our precedents do not require the cessation of questioning. Rather, the suspect must unambiguously request counsel. As we have observed, a statement either is such an assertion of the right to counsel or it is not. Although a suspect need not speak with the discrimination of an Oxford Don, he must articulate his desire to have counsel present sufficiently clearly that a reasonable police officer in the circumstances would understand the statement to be a request for an attorney. If the statement fails to meet the requisite level of clarity, Edwards does not require the officers to stop questioning the suspect. The interrogation must cease until an attorney is present only if the individual states that he wants an attorney. We decline petitioner's invitation to extend Edwards and require law enforcement officers to cease questioning immediately upon the making of an ambiguous or equivocal reference to an attorney. The rationale underlying Edwards is that the police must respect a suspect's wishes regarding his right to have an attorney present during custodial interrogation. But when the officers conducting the questioning reasonably do not know whether or not the suspect wants a lawyer, a rule requiring the immediate cessation of questioning would transform the Miranda safeguards into wholly irrational obstacles to legitimate police investigative activity. Because it would needlessly prevent the police from questioning a suspect in the absence of counsel, even if the suspect did not wish to have a lawyer present. Nothing in Edwards requires the provision of counsel to a suspect who consents to answer questions without the assistance of a lawyer. In Miranda itself, we expressly rejected the suggestion that each police station must have a station house lawyer present at all times to advise prisoners, and held instead that a suspect must be told of his right to have an attorney present and that he may not be questioned after invoking his right to counsel. We also noted that if a suspect is indecisive in his request for counsel, the officers need not always cease questioning. We recognize that requiring a clear assertion of the right to counsel might disadvantage some suspects who, because of fear, intimidation, or lack of linguistic skills, or other reasons, will not clearly articulate their right to counsel, although they do actually want to have an attorney present. But the primary protection afforded suspects subject to custodial interrogation is the Miranda warnings themselves. Full comprehension of the rights to remain silent and a request for an attorney is sufficient to dispel whatever coercion is inherent in the interrogation process. A suspect who knowingly and voluntarily waives his right to counsel after having that right explained to him has indicated his willingness to deal with the police unassisted. Although Edwards provides an additional protection if a suspect subsequently requests an attorney, questioning must cease. It is one that must be affirmatively invoked by the suspect. In considering how a suspect must invoke the right to counsel, we must consider the other side of the Miranda equation, the need for effective law enforcement. Although the courts ensure compliance with the Miranda requirements through the exclusionary rule, it is police officers who must actually decide whether or not they can question a suspect. The exclusionary rule is a rule that says that if the police don't do something correct in the chain of evidence, or like your Miranda rights as well, everything that comes from that mistake or improper procedure is thrown out and is excluded from the case. And this is why sometimes you might see a suspect who is clearly guilty walk free because there was some kind of mistake or something on the police or prosecutor's part, and some key piece of evidence is not allowed in. So back up here, when they say, although the courts ensure compliance via the exclusionary rule, they mean that the police officers suffer the punishment of losing the case, basically, because they did not put the case together procedurally sufficiently. So starting back here, the Edwards rule that questioning must cease if the suspect asks for a lawyer provides a bright line that can be applied by officers in the real world of investigation and interrogation without unduly hampering the gathering of information. But if we were to require questioning to cease if a suspect makes a statement that might be a request for an attorney, this clarity and ease of application would be lost. Police officers would be forced to make difficult judgment calls about whether the suspect in fact wants a lawyer, even though he hasn't said so, with the threat of suppression if they guess wrong. We therefore hold that, after a knowing and voluntary waiver of the Miranda rights, law enforcement officers may continue questioning until and unless the suspect clearly requests an attorney. Of course, when a suspect makes an ambiguous or equivocal statement, it will often be good police practice for the interviewing officers to clarify whether or not he really wants an attorney. That was the procedure followed by the NIS agents in Davis. Clarifying questions help protect the rights of the suspect by ensuring that he gets an attorney if he wants one, and will minimize the chance of a confession being suppressed due to subsequent judicial second-guessing as to the meaning of the suspect's statement regarding counsel. But we decline to adopt a rule requiring officers to ask clarifying questions if the suspect's statement is not an unambiguous or unequivocal request for counsel. The officers have no obligation to stop questioning him. To recap, we held in Miranda that a suspect is entitled to the assistance of counsel during custodial interrogation, even though the Constitution does not provide for such assistance. We held in Edwards that if the suspect invokes the right to counsel at any time, the police must immediately cease questioning him until an attorney is present. But we are unwilling to create a third layer of protection to prevent police questioning when the suspect might want a lawyer. Unless the suspect actually requests an attorney, questioning may continue. The courts below have found that petitioner's remark to the NIS agents, "Maybe I should talk to a lawyer," was not a request for counsel, and we see no reason to disturb that conclusion. The NIS agents were therefore not required to stop questioning petitioner, though it was entirely proper for them to clarify whether petitioner in fact wanted a lawyer. Because there is no ground for suppression of petitioner's statements, the judgment of the Military Court of Appeals is affirmed. So what do you think of that? That makes it clear that the police officers need to have an unequivocal, unambiguous, and clear statement that the defendant wants a lawyer. So let's go back to this statement from the judge. Now, let's remember that the statement that the suspect made here, "If y'all, this is how I feel. If y'all think I did it, I know that I didn't do it, so why don't you just give me a lawyer, dog, because this is not what's up." So that to me does not seem to be an unambiguous, clear statement that he wants a lawyer in the room with him right now. It does seem to be a "maybe I should have a lawyer" statement. And it would seem proper to me to have the police officers stop and ask him, "Are you asking for a lawyer? Would you like to have a lawyer present? We'll stop all questioning and go get you a lawyer," or whatever, as you saw in the Davis case. And I don't see any facts in this judge's concurring opinion that those things happened. So if Warren de Meme, or however it's pronounced, sorry Warren if you're watching this, if Warren appeals this, he would have the grounds to appeal that he made a less than ambiguous statement and that the judge's misinterpretation by saying that he was asking for a, quote, "lawyer dog," that was some kind of arbitrary or capricious, some kind of a willful misunderstanding. And that's a bit of a stretch, I think. But if the state of Louisiana comes back and says, "Well, yeah, the judge said lawyer dog, but that wasn't the real thing. It's really just an ambiguous statement. If y'all, this is how I feel. If y'all think I did it, I know that I didn't do it. Why don't you just give me a lawyer dog?" I don't think that there's any need to go to lawyer dog. I think you can just focus on, why don't you just give me a lawyer? Because if you compare that to the Naval Investigative Services in the Davis case, the defendant said, "Maybe I should have a lawyer," and that was not enough. It was enough for the police to do the right thing in the ethical sense, in the spirit of the law, to stop questioning and ask him if he really wanted a lawyer. But the judges said clearly in Davis that was not a unambiguous, clear statement that he wants a lawyer. So if Warren says, "Why don't you just give me a lawyer," whether or not he says the word dog, that's not a statement that is clear and unambiguous enough on this standard to get him a lawyer and stop the questioning. So he still loses here, in my opinion. So what do you think of that? Did you learn something about your rights? And if you ever get arrested, do you now know what you have to do if you want to invoke that right to a lawyer? I sure hope you do, because that was pretty clear. So please let me know what you think of that in the comments below. And I have on Twitter at Leonard J. French, and we have a Discord channel, which will be in the description of the video. Meanwhile, I'm being hit pretty hard by the adpocalypse, with most of my videos being demonetized and me having to change my workflow to produce videos. YouTube doesn't give us any help with telling us if a video is okay before it gets demonetized. You have no way of knowing. I'm really relying on the support of my patrons and other supporters, but mostly through Patreon. So if you'd like to see more of these videos, or you just like to support me in general, please go to patreon.com/ljfrench and support there. I would like to thank AVE. Arduino Evil is one of my Patreon supporters this month. He has supported a video, he sponsored a whole video on the Milwaukee versus Snap-on lithium-ion battery tool patent case. which Milwaukee recently won, and I think there was a $28 million judgment or something like that. I also have supporters at the $50 level who I call out by name: John Steele, Westin, Lohne, Nate, Beck, Lydia, Collinson, and Gavin, Barnard. Thank you for supporting me for the month of November with your donations. And there are a number of $5 plus supporters who are scrolling on the LED panel behind me and are in the description of the video below, as well as 100 plus supporters who don't wish to be named and are supporting at the $1+ level. All of you get special privileges on my Discord channel. You get recognized there with a special tag, special color, and your own channel and voice chat to talk to me. I pop in there occasionally. So thank you all for joining me. I'm Leonard French, your favorite copyright attorney. I will put some other things on the end screen here so that you can see some things, and I'll keep talking for 20 seconds so that you don't have to have those end screen things on the previous screens. And I'll see you in my next video. Thank you very much. Love you all.